just for the purposes of the meeting, I'll just go through who is present. We have Honorable Maleka, Honorable Bartlett, Honorable Mtetwa, Honorable Smith, no. Sorry, Honorable Motamai, my apologies, the screen is jumping. Honorable Dlamini, Honorable Badenhorst, Honorable Dudovu, okay, once again, welcome honorable members. I hope I didn't miss any honorable member, but you're welcome. Maybe also just take this opportunity. I see Honorable Badenhorst is here. You have been welcome to the cluster, but once again, welcome to the committee. On members, just in terms of today's meeting, let me deal with apologies before that. We do have an apology from Honorable Dango, Honorable Mikolakis, and Honorable Ndongeni to the meeting. Let me also maybe welcome also the legal team from the Department of Justice that's also on the platform, but also to indicate that we do have an apology as well from Honorable, sorry, I see Honorable Smith is present as well in the meeting. Welcome, Honorable Smith. As I indicated to Honorable Badenhorst that we welcomed him to this committee. Let us welcome you as well, even though we welcomed you to the cluster previously. We also have an apology from the parliamentary legal advisor. Unfortunately, she was double booked for today because there's also another meeting in the NA that is running at the same time. But that being said, honourable members, we expecting a briefing by the Department of Justice and Constitutional Development on the written submissions we received on the Land Court Bill. And secondly, we want to consider and adopt the report of our proactive oversight visit in the Free State. And this is in relation to the housing benefits to military veterans in that province. Okay, I think, our members, if I can just indicate that we met on the 12th of October, where we received a briefing by the department that was last year on the Land Court Bill. And maybe just to recap briefly, the bill aims to provide for the establishment of a land court and appeals against decisions of the land court. The bill aims to make provision for the administration and judicial functions of the land court, to provide for the concurrent jurisdiction of the land court and the magistrates court for certain land-related matters, to provide for mediation procedures, to amend certain laws relating to the adjudication of land matters by other courts, and to provide for matters connected herewith. And I think in terms of the briefing previously, I think members also positively received the presentation by the department. In terms of the public participation process and related to the submissions that were received, the bill was advertised for public comments from the 14th of October to the 11th of November 2022. As a committee, we received through the GeoSA petition 10,594 petitions from the GeoSA. In addition to that, we received 11 submissions, which broadly focus on the issues or main concerns were around the tagging of the bill as a Section 75 bill, the lack of socio-economic impact assessment, the scope of jurisdiction of the court, which needs clarity, the appointment and competency of judges in the land court, the role and competency of assessors in the land court, the admissibility of hearsay evidence, and the role of magistrates should be clearly set out in the bill. Those were the issues around which comments were received. And today, honourable members will receive the departmental responses to the submissions made on the bill. And thereafter, honourable members will continue with our deliberation on the bill. And I think what you can see on the screen as well is just the the 11 organizations that have made inputs, substantive inputs into this bill. That being said, honourable members, I'm going to hand over to the department. But before that, the issue of the tagging as a Section 75 bill that has been raised in the submissions. Honourable members, given that the Parliamentary Legal Advisor is not here today, we'll then take a presentation from Legal Services to clarify this aspect as well in our next meeting. That being said, let me then hand over to the Departmental Legal Service. I see Mr. Dupree is here, and I'm not sure. Okay, let me hand over to the department. I think they'll just guide us in terms of indicating who's going to lead with their presentation. Over to you.
Good morning, Madam Chair and members of the committee. Thank you very much. Madam Chair, Mr. Makulubete and I agreed that he will lead the committee through the summary of the comments and the department's responses thereto. So with your permission, I would like to hand over to Mr. Makulubete. Thank you, ma'am.
Thank you very much. Please continue, Mr. Makulubete.
Thank you very much, Chair, and good morning, honorable members. Chair has already given a background as to what the briefing dealt with on the 12th of October last year. And on the screen, I hope everyone can be able to see the screen. It is a summary of the comments that we have received in relation to the bill. And this briefing document is divided into two tables. The one being the specific comments that we have received on the bill in relation to each and every one of the clauses of the bill. And table 2 will deal with the general comments, those that do not talk to specific provisions of the bill. With that being said, Chair, I would like to start with the comments that we have received in relation to the preamble. We have a group of role players, Agri-SA, Agri-SA Mpumalanga, AfriForum, and the Free State Agriculture. They are submitting that the preamble should not create the impression that the land court in itself will ensure speedy and sustainable land reform. They are submitting that the various reports, such as the high-level panel report on key legislation, have also pinpointed the problems causing the slow pace of land reform, and these have little to do with the courts. However, Chair and honorable members, it is our submission that the land court itself is being established to remove the challenges that have been experienced by the land claims court through capacitating the judicial officers of the land court. The land court is essentially intended to accelerate the process of land reform in relation to matters that are before the court. They are created by the backlogs which were caused by the lack of sufficient judges to deal with many land matters that are before the land claims court. I would like to pause here, Chair, to just go back to the briefing that we gave to the committee on the 12th of October to say that what we are trying to do in terms of this bill is to create the land court, as the Chair has correctly alluded to. This land court is going to replace the current land claims court. This land claims court has been established by the Restitution of Land Rights Act, and this court was mainly established to deal with restitution of land rights or restitution claims. This court also had a concurrent jurisdiction with to deal with matters emanating from the Labor Tenants Act, and it also shared jurisdiction with the on the matters arising from the from ESTA, Extension of Security of Tenure Act. So now what we are doing is to say that because that court was established with a short lifespan, it had a limited lifespan, because at that stage it was thought that the process of restitution will be a short one. Hence, the court was not established as a permanent court, and the court was not capacitated with sufficient number of judges to deal with restitution matters. However, it turned out, Chair, as I've mentioned in the previous briefing, that the restitution claims became a protracted a process, and it became complicated, resulting in the backlogs. So now what we are trying to do is to come up with a legislative framework that will deal with those backlogs that came about as a result of the court not being a permanent court with insufficient judges to deal with those matters. So we are establishing the land court to capacitate the court with a sufficient number of judges to deal with matters. And it's not only going to deal with the restitution, the labor tenants, and ESTA matters. It's intended to ultimately deal with all land-related matters. Chair and honorable members will remember that in the schedule to the bill, we have listed only 9 pieces of legislation over which we are giving the land court jurisdiction. We are saying that in the long run, other pieces of legislation are going to be included under the jurisdiction of the land court. So for now, we are trying to start at the lowest level, so as to ensure that the court, as is so newly established, can be able to manage the matters that are before the court. Going further, Chair, the comment from LAMOSA, they are making a proposal for the insertion of an expression in the preamble to read, and since the Constitution and our courts recognize customary property rights, customary land and resource governance, and customary rules of evidence. So it is our submissions that if you look at the preamble itself, it makes reference to Section 25 of the Constitution, which section obliges the state to take reasonable legislative and other measures to foster conditions which enable citizens to gain access to land on an equitable basis. Chair, it is our view that this recognizes the need to ensure access to land in general, and will also include property rights that are being advocated by LAMOSA. Also, Chair, the second paragraph makes reference to Section 7 of the Constitution, which obliges the state to respect, protect, promote, and fulfill the rights in the Bill of Rights, and this includes protection of right to customary land. In short, Chair, we are not in support of inserting the expression as proposed by LAMOSA. Chair, going to clause 1 of the bill, so a clause dealing with the definition. Agri-SA and Free State Agriculture submit that the definition of act should not include the regulation. However, Chair, we are not in agreement with them because it is intended that where the reference is made to the act, that should be read to include the regulation. However, that will depend on the context. Chair, it is tried that where the substantive provisions of an act should be supplemented by means of regulations, that definition of act will include reference to the regulations. Furthermore, Chair, it is submitted that the definition of a claim, claimant, and commission will be better placed in the Restitution of Land Rights Act. We are not in support of this submission because in the bill itself, there are references to these terms, that is claim, claimant, and commission, and therefore they need to be defined because of their reference to in the bill. Furthermore, Chair, the definition of rules should be amended to mean rules made by the court, made for the court by the judge president and or the rules board. Chair, the intention of the bill is to have the rules board making the rules for the court. This is covered in clause 4 of the bill, which empowers the rules board to make the rules. I will remember, and honorable members, that the rules board for courts of law has been established as a body that that makes rules for the courts of the Republic, obviously excluding the rules of the Constitution, of the Constitutional Court, and also the rules for the Labor Court. So the rules board deals with all the with the rules of all courts of the Republic. Chair, the Legal Resources Center make a submission that the definition of claim refers to a claim for restitution of a right in land in terms of the Restitution Act. They submit that it should be extended to all claims made in terms of any land-related legislation. We know this submission, Chair, but we are not in support thereof, because the definition of claim relates specifically to a claim under the Restitution of Land Rights Act. So wherever the term is encountered in the bill, if I can so say, if the claim is encountered in the bill itself, it will mean that claim refers to a claim under the Restitution of Land Rights Act. Chair, clause 2 deals with the purpose and object of the Act, and it is submitted by Agri SA, Free State Agriculture, and Agri SA of Mpumalanga. That clause 2 is misleading and should be deleted or amended, as a court cannot enhance and promote access to land. They are submitting, Chair, that this legislation should focus on the establishment, powers, and functions of the court, which is to adjudicate land dispute in an equitable manner. Chair, we are not in support of this submission because access to land is intended to be enhanced and promoted by adjudication in the land court. By being a dedicated permanent court, this land court will adjudicate on and resolve land disputes, and thereby contributing towards the ideal or goal of access to land. Chair, going on to clause 3, which deals with the establishment of the court, we have received a submission that it is not clear what a court of equity is. The submission is that it is not clear how a court can be both a court of law and a court of equity. They are submitting that the words and equity should therefore be deleted. It is their view that judges must apply the law and should not be entitled to disregard the law in favor of an outcome to litigation which that judge deems to be equitable. However, Chair, in our response, we are saying a land issue is a matter that requires equity consideration in some instances. For instance, Chair, if you have a look at Section 33C of the Restitution Act, that section requires that equity be considered as a factor when the court makes a decision. Therefore, the court, that is the land court, should not be confined to being a court of law, but must follow equitable consideration when necessary. So you will also recall, I'm making reference to Section 151, one of the Labor Relations Act, which also establishes the land court as a court of law and equity. So this is not a strange phenomenon that we come up with in the bill. However, it exists in the Labor Relations Act. Chair, it is proposed that it is submitted that the proposed land court is not a high court. It is doubtful whether national legislation can bestow inherent powers on the land court. Therefore, the first line of clause 32A should be replaced, and then they make a submission and a proposal in that respect. However, Chair, we are submitting that the land court is established as a superior court, which has authority and a standing equal to that of a high court. So as long as there exists the high court, this land court will have the authority and the equal standing of the high court. And this is as contemplated in the constitution, particularly in section 166E of the constitution. And also it has inherent powers as the high court as contemplated in section 173 of the constitution. Chair, Legal Resources Center submits that it is unclear whether the provision relating to a court of law and equity applies only to the Restitution of Land Rights Act and other legislation which expressly provide for a law and equity. They suggest that the reference to the Restitution of Land Rights Act be removed and that the provision simply state that the land court is hereby established as a court of law and equity. Chair, the comments that we have received when this bill was serving before the portfolio committee, most of them were opposed to us establishing the land court as a court of law equity as well. Certain legislation such as I've mentioned, the Restitution Act requires the concept of equity be considered when the court decides on a matter. As such, the Restitution Act requires the court to consider equity as well as any other legislation that requires equity to be considered. So, Chair will recall the way we phrased it. We made sure that other pieces of legislation that will be considered by the court, if those pieces of legislation that require that equity be considered, then the court will, in those instances, consider equity. Chair, Clause 6 deal with seat of court, and the Afric Forum submits that a court that deals with land-related matters should rather be situated in Pretoria, where all ministers are. However, it is our submission, Chair, that this bill follows the seat of the Land Claims Court, which is currently located in Johannesburg. However, Chair, it is our submission that the seat of the court is not dependent on the location of the offices of the ministers. Chair, it is submitted that by Agri SA and Free State SA, they say it is unclear what is intended by clause 6.2 regarding the reference to may sit in many different courts. This subclause should be deleted, as said clause 6.1 already provides for sittings of the court at venues elsewhere than at the seat of the court. If the court sits at the venue elsewhere than at the seat of the court, it is not a separate court. It remains the same court. Furthermore, Chair, they are submitting that not all litigants are able to travel to Johannesburg, and the fact that the seat of the court is situated there will place a financial burden on the parties to the dispute, resulting with the court's jurisdiction. They are submitting that ease of access and administration should be on the forefront. Chair, in response to this submission, it is our submission that clause 6.1 is different from clause 6.2 because 6.1 permits a matter to be held elsewhere than at the seat of the court, whereas clause 6.2 permits the land court to hold its sittings in separate courts all at the same time. So there are differences in this differences between these two subclauses. And reference is made also to Section 33 of the Superior Courts Act. Jurisdiction of the court is covered by Clause 7, Chair. AfriForum expresses the view that the scope of court jurisdiction must be clarified and points out that the flexible scope of the court's jurisdiction is vague and overbroad. Chair, it is our submission that the bill as it stands is clear as to the jurisdiction of the court, read with the proposed amendments to those pieces of legislation listed in the schedule to the bill. The jurisdiction of the court will be incrementally expanded by means of amendment to other principal acts. As I've mentioned, Chair, we only have 9 pieces of legislation which will immediately fall under the jurisdiction of the court once the bill comes to operation. And if other pieces of legislation are intended to be placed under the jurisdiction of the court, then necessary amendments will be made to those specific pieces of legislation. Chair, AfriForum expresses a concern that the executive, acting through the minister, may increase the scope of jurisdiction in its discretion. The minister, Chair, is not empowered by Clause 7.3 of the bill to increase the scope of the jurisdiction of the court. Instead, Clause 7.3 aims to empower the minister to determine only the area of jurisdiction of the court. Therefore, the provision is necessary, Chair, to enable the minister to establish, increase, or decrease the area of jurisdiction. Chair, this is not a new provision. It also applies currently in as far as the high courts are concerned. Chair, it is further submitted that should eviction matters falling outside the scope of ESTA be heard by the court, for example, as has been referred in the media, the consequences will be catastrophic given the uniquely relaxed evidentiary standards proposed in the relaxed evidentiary standards of the proposed land court. Chair, it is our submission that only principal legislation dealing with eviction matters can enjoy the jurisdiction of the court only if those pieces of legislation affords the land court jurisdiction to deal with matters emanating from those pieces of legislation. So it is further submitted that it is not clear what is meant by each court in Clause 7.3. If it is the intention to establish separate division or satellite seats of the land court, each with its own area of jurisdiction, judges and the administrative staff, it should be clearly stated in the bill. Particulars should be given on how each division or satellite seat will operate. However, Chair, our submission is that the intention of the bill is to establish the court, that is the land court, which may hold its sittings elsewhere other than at the main seat. And the court established elsewhere should have the area of jurisdiction that it serves. We do not have an intention to establish any division of the land court or a satellite land court. Chair, the Free State Agriculture submits that not only the minister should determine where sittings of the court should take place. They are submitting that although the Chief Justice will be consulted in this process, it may be necessary that the Judge President of the court is also delegated the authority to make such decision. Chair, the minister and the Chief Justice will be advised by the Judge President as and when it is necessary in this instance. So their submission is not supported because now there will be consultation between the Minister, the Chief Justice, and the Judge President. The Land Claims Court, Chair, I must pause here to mention that the submission we received from the Land Claims Court were penned on behalf of the judiciary by Judge President Mie. That is the acting Judge President of the Land Claims Court. The current Land Claims Court is being overseen by Judge Mie, who is the one who penned the submissions for the judiciary. As such, Chair, going forward, I must mention that they are proposing that clause 7.1 be amended to read, subject to the Constitution and except where this Act or the Restitution of Land Rights Act 22 of 1994 provides otherwise, the court and the magistrate court within whose area of jurisdiction the land forming the subject matter before that court is situated have concurrent jurisdiction in respect of all matters in terms of this Act or in terms of any other law to be determined by the court. Chair, our submission is that you will recall in terms of the schedule we have listed those 9 pieces of legislation which grant the jurisdiction to the land court. The Restitution Act is one of those, and it is amended in the schedule itself so as to give the land court jurisdiction over it. So if we have to insert the Restitution Act as proposed by the Land Claims Court, that could give a negative impression, Chair, that the magistrate courts are also granted jurisdiction to deal with restitution matters. My apologies for a typo there. It should be a restitution instead of expropriation. So if we have to include restitution there, it will mean, therefore, that the magistrate are likely given, or the magistrate court are also given jurisdiction over the restitution matters, which is not the case as per this clause. So also, if we do this, Chair, the question will arise as to why we do not include other pieces of legislation in this clause. So it is not our intention to insert this proposal, and it will lead to unintended consequences if we do so. Socioeconomic Rights Institute Chair submit that the legal issues that arise in matters concerning the land and housing legislation over which the land court has jurisdiction are likely often to raise related legal questions about common law, customary law, contracts, administration of estate, and other legislation and regulations not listed in the bill. The Equality Court and the Labor Court have both faced such challenges relating to the jurisdiction in mixed issue matters at the intersection of different areas of law. Chair, our submission refers to clause 24.1c, which enables the court to decide any issue in terms of any other law, which is not ordinarily within its jurisdiction, but is incidental to an issue within its jurisdiction if the court considers it to be in the interest of justice. For instance, Chair, if I may make just one example for clarity's sake, if a matter, let's say a restitution matter, is before the land court, and the issue arises as a dispute between the parties with regards to the maybe Property Valuation Act, that act is not within the jurisdiction of the court. However, because the court is faced with a restitution matter before it, the court is able to, through this clause 24.1c, is able to deal with the Property Valuation Act because it is, or the issue will be incidental to the matter that is before the court, that is through the restitution of Land Rights Act. Chair, it is further proposed the insertion of a reasonably ancillary clause to give the land court jurisdiction over issues connected to those issues over which the bill gives it a jurisdiction in the same case. On the same vein, Chair, 24(1)(c) covers this proposal, except that the word reasonably is not supported, as that will unnecessarily qualify the ancillary or incidental nature of the issue. It is our submission, Chair, that an issue will be ancillary or incidental or not, and the court will not have to decide if it is ancillary or incidental. The standard of reasonably is a standard will unnecessarily force the parties to engage in the dispute as to the reasonableness of the ancillary nature of any dispute before the court. Chair, it is further proposed the inclusion of a transfer provision that will enable the magistrate court, the high court, or a land court, in the event that it finds that it lacks jurisdiction, to transfer the matter to the appropriate court. This, Chair, is submitted will avoid the need to dismiss matters for lack of jurisdiction and force parties to start again in the correct forum. In this regard, Chair, they are making a reference to Section 20 of the Equality Act, which contains a provision dealing with the transfer of matters. However, Chair, this proposal is not supported. We are referring to Section 27 of the Superior Courts Act, which allows the transfer to take place in certain circumstances, as contained in that Section 27. The transfer clause should not be used to cure the error by a litigant in choosing the wrong forum. Chair, it has been an established legal principle that whoever chooses a court is bound by that court. If there's an error in terms of the jurisdiction of that court, that party will be forced to withdraw the case before that wrong court and institute the proceedings afresh in the correct forum. And furthermore, Chair, the transfer that is contemplated in Section 20 of the Equality Court is not the transfer that they are talking about. This is the transfer where the clerk of the Equality Court has received a notice of intention to institute proceedings, and not where the proceedings have already been instituted. That is, once the clerk receives the notice of institution of proceedings, then that matter will be transferred, whether for a mediation or arbitration or to court. This is what they are. This is what the clause is. This Section 20 of the Equality Act is referring to. Chair, there are further proposals as follows. It is proposed, there's three of these proposals which I'm going to combine together. The proposal to retain the High Court jurisdiction in relation to PI matters for a transitional period until the Land Court has sufficient number of judges to manage the massive PI caseload currently managed by the High Court across the country. Secondly, amending the bill to guarantee the appointment of a sufficient number of dedicated Land Court judges sitting across the country to adjudicate PI matters at first instance and on appeal. Thirdly, Chair, providing for the appointment of sufficient number of High Court judges in every High Court division as Land Court judges, so as to ensure sufficient capacity. Chair, to retain the jurisdiction of the High Court will defeat the purpose of having the Land Court ultimately dealing with all land-related matters. The intention is to say that ultimately the Land Court will have to deal with all matters. However, at this stage, the court is not going to deal with all those land-related matters, and in due course, the court will be able to deal with all land-related matters. However, will not want to retain the jurisdiction of the High Court. All the matters that are going to be dealt with in the Land Court are going to be dealt with specifically by the Land Court, to the exclusion of the High Court. Chair, the Land Court will, upon inception, be fully capacitated with enough judges to manage the caseload. We have a specific clause, Chair, in the bill that allows the appointment of judges. And I believe then the appointment will ensure that the judges that are appointed will be sufficient to deal with the caseload that will be before the court. Chair, Legal Resources Center submits that many legal disputes that relate to land rights do not necessarily arise from the legislation that is listed in the bill. The proposed land court should be empowered to deal with disputes arising from other pieces of legislation in as far as they may threaten land rights of customary communities and land reform beneficiaries. Land court should include matters which are reasonably ancillary to the listed legislation. Chair, I have made mention to clause 24(1)(c), which is also applicable here. The intention, Chair, is to adopt an incremental approach in terms of which the land court will deal with certain land-related matters for now, and other land-related matters will be placed under the jurisdiction of the land court at a later stage. We do not want to unnecessarily burden the court with all land-related matters at this stage. However, the court chair will not be deprived of the power to matters that are not listed in the schedule to the bill, and this will be in terms of the that clause 24(1)(c), which enables the court to deal with matters which are ancillary to the matter before the court. It is submitted further that the expansion of the land claims court jurisdiction will increase the caseload of the land court significantly. At the moment, Chair, the land claims court has 4 judges, but the judicial and administrative capacity of the court will have to be expanded in order to manage the potential caseload. Chair, we are agreeable with this. We note it, but hence we have drafted the bill in a manner that will provide for the appointment of the judiciary and staff that will be sufficient to deal with anticipated caseload. So this submission is already covered in the clause in terms of the appointment of sufficient judiciary and staff of the court to manage the caseload. Chair, it is submitted that the bill confers concurrent jurisdiction on the land court and magistrate court for cases under a range of legislation to the exclusion of the High Court. There are difficulties which may arise in practice with this concurrent jurisdiction. Chair, they are listing submission in relation to their submission, and in the first instance, they are saying there is currently limited capacity in the magistrate court to deal with all PI and ESTA cases. Chair, the bill only removes the jurisdiction of the High Court in dealing with PI and ESTA matters, and this jurisdiction is placed under the land court. But the magistrate court's jurisdiction is still retained. The capacity or the lack thereof in the magistrate court is not created by the bill itself. So the position is as it is. The limited capacity is not necessarily created by the bill itself. Chair, it is unclear which rules will apply where cases are heard in the magistrate court, particularly where there is a need for the hearing of oral evidence. Chair, the rules of the magistrate court will apply in the magistrate court like it applies in all other matters that are before the magistrate court. So if the matter is before the magistrate court, the rules that are applying in the magistrate court will continue to apply in the normal course. Chair, it is further submitted that it is unclear whether any specific training will be provided to magistrates, particularly those who have no experience in land matters, to capacitate them to be able to deal with such matters effectively. Chair, the training of magistrate will continue in the normal course, and that matter is not for incorporation in the bill, but it's a matter that will be dealt with in the legislation that deals with magistrates, not in the Land Court Bill. It's further suggested that the High Court retain jurisdiction to hear PI and ESTA cases until such time as the Land Court is sufficiently capacitated to be in a position to hear such matters. Chair, as I've mentioned before, the intention is to have the Land Court ultimately dealing with all land-related matters, and the court will be fully capacitated with sufficient judges to manage the caseload. Clause 8, Chair, deals with appointment of judges of the court. AFRI Forum is of the view that there should not be an overemphasis of race or gender when it comes to the appointment of judicial officers. Chair, it is our submission that the intention of Clause 8 is to require that race and gender are considered, but not to be a determining factor. In that clause, Chair, there are 3 categories that have been listed for consideration. That is the expertise, race and gender, and the candidate should be appropriately qualified. So essentially, our submission is that there is no overemphasis on the concept of race and gender, but this is one part of the factors to be considered for the appointment of judicial officers. AGRI-SA submits that the requirement of training and experience in the field of land rights matters will significantly limit the pool of potential appointees to the bench of the Land Court. They suggest that this requirement be removed as an essential requirement, although it could be retained as a factor to be considered in the selection of suitable appointees. Chair, the intention of the bill is to appoint persons on the bench who are experienced in land matters. This is similar to the position under the Labor Relations Act, Chair, which requires the appointment of judges from those candidates with knowledge, experience, and expertise in labor law. So we are following the same approach as in the Labor Relations Act in relation to this clause. The Institute of Race Relations submits that the requirement that judges must be representative in terms of race and gender is inconsistent with Section 174 of the Constitution and is invalid, as that section requires that judges must first and foremost be appropriately qualified, people who are fit and proper to serve on the bench. Chair, Section 174(2) of the Constitution provides that the judiciary must reflect broadly race and gender composition of South Africa. This clause 84B is actually similar to Section 174, which requires race and gender representation. However, Chair, we have picked up the correction that we may effect in due course by the insertion of the word broadly, so as to align in full with Section 174(2) of the Constitution, as it requires that candidates be broadly representative of gender and of race and gender. Chair, it is submitted further that given the importance of a sound adjudication on complex and vital land issues, the bill should be amended to provide that all judges appointed to the court must already be judges with significant judicial experience at the time of their appointment. Chair, the intention is to appoint persons to the bench of the Land Court who are experienced in land matters, similar to the position under the Labor Relations Act, which requires knowledge, experience, and expertise in labor law. It is submitted further, Chair, that the bill states that all judges appointed must have expertise in the field of land rights matters. The wording will encourage the appointment as judges of land activists with narrow and partisan views on land issues, rather than with the objectivity needed for balanced and independent adjudication. Chair, it is our submission that the intention of the bill is to ensure that persons appointed in the bench are also experienced judges, so as to not all the appointees, Chair, are taken only from the pool of magistrate, advocates, and attorneys. So the intention is to open that possibility for those who will have experience and expertise can be amenable for appointment or qualify for appointment to the bench of the Land Court. Chair, it is proposed by the Land Claims Court that clause 8.3 be amended to read: the President, acting on the advice of the Judicial Service Commission and the Judge President of the Court, may, subject to subsection 4, appoint as many judges as is necessary as judges of the court, who are judges of the High Court at the time they are appointed to the court, and such judges shall hold concurrent appointment in the court and a relevant division of the High Court. Chair, we are not in support of this proposition, as the intention is to appoint judges solely to the Land Court, without those judges exercising concurrent appointment to the Land Court and the High Court. The intention is to say all the judges that we are appointing should be judges of the Land Court and not of the High Court at the same time. Chair, it is proposed that in addition to expertise in the field of land rights matters, in clause 8.4a of the bill, that a requirement be inserted that there should be a demonstrable commitment to land reform. It is submitted that this will ensure that the Land Court judges not only have technical expertise, but the commitment to the overall constitutional imperative of land reform that can be demonstrated by their professional background. Chair, we do not support this proposal. It is not necessary and may be too restrictive to the appointment of suitable judges. The concept of a demonstrable commitment to land reform will be unnecessary. Chair and honorable members are aware of the high standard of the processes in the Judicial Services Commission when they appoint judges. We do not want to unnecessarily restrict those processes by requiring the panel to determine if the candidate has a demonstrable commitment to land reform. We will want those processes to be robust as they are. Chair, it is further proposed that to ensure the security of tenure, independence, and status, and to ensure that enough judges are appointed as Land Court judges, that all Land Court judges should concurrently serve as High Court judges. As I have mentioned before, Chair, we do not intend to have judges being appointed concurrently to the Land Court and the High Court. It is submitted that clause 8.3 of the bill provides that persons appointed as Land Court judges may have been judges of the High Court. This entails, Chair, that Land Court judges are not required to have been judges of the High Court, and it is not clear if, when appointed, the Land Court judges are also appointed as judges of the High Court. Furthermore, Chair, it is submitted that clauses 8 and 9 should be reviewed so as to ensure that all judges appointed to the Land Court are also the High Court judges. Chair, on the same vein, we do not intend to make a simultaneous appointment to the High Court and the Land Court. It is submitted by the Land Resources Center, Chair, that whilst there are clear criteria for the appointment of Land Court judges in the bill, there is no corresponding criteria for magistrates who will be called to adjudicate land dispute. It is therefore suggested that the bill be amended to include such criteria for magistrates who will specifically deal with land matters. Chair, it is not possible to do this. The appointment of magistrate will be dealt with in their own legislation. It cannot be dealt with in this bill that deals with the land court judges, and the criteria that is used for the appointment of the land court cannot be used for the appointment of magistrates. It is furthermore submitted that the bill should stipulate a minimum number of permanent judges for the land court to ensure that the court is sufficiently capacitated. Coupled with that, Chair, it is submitted that the decision on the number required for the bench should not be taken in a vacuum, but has to take cognizance of the actual number of cases that the court could potentially adjudicate. Too few judges tasked with too many cases could negate the objectives of the land court and the act. Chair, the clause empowers the President of the Republic to appoint as many judges as is necessary to the bench of the land court. This, Chair, essentially will enable the land court to be sufficiently capacitated. And Chair, I must add that there is an established criteria in terms of section 49(1)(b) of the Superior Court that deals with the appointment of the judges of the High Court. Clause 11, Chair, deals with appointment of officers and staff of the land court. AfriForum objects to the minister's power to appoint officers and staff of the court and argues that the court should be insulated from accusation of influence. Chair, the approach that is adopted in this clause is a standard approach and is essentially an administrative function that is normally performed by the minister. What is important, Chair, is to note that clause 11(1)(c) provides that the court manager exercises administrative control over other officers and staff, and does so under the control and direction of the judge president. So the intervention or the participation of the judge president in the process is key, and it will cover the submission that is made in this regard. It is further proposed, Chair, by SERI that amendments be made so that the appointment of officers and staff of the court be removed from the executive control and placed under the judicial control. Chair, the minister makes these appointments in accordance with the public service law, and the fact that they are made in consultation with the judge president of the court is essentially to ensure that the appointments do not interfere with or hamper the judicial interference. Chair, going on to clause 12, which deals with the appointment of assessors. The submission is that it is not clear what is meant by the words that assessors must be appointed in the prescribed manner in subclause 2. Assessors should be persons who, in the opinion of the judge who presides in the trial, has experience in the administration of justice or skill in any matter which may be considered at the trial, and should be selected and appointed by the presiding judge. Chair, it is envisaged that the regulations or the rules will set out the general provision for the appointment of assessors. This will be covered in clause 36(1) of the bill, which deal in general with the regulations that will be made by the minister. This provision, Chair, simply means that the minister will be empowered in terms of that clause, and specifically paragraph D and E, to prescribe the manner of appointment of assessors and the form of the oath or affirmation that will be applying to those assessors. It is further proposed, Chair, that the role given to the rules board in relation to mediators be extended to assessors, and that all assessors of all aspects of both mediators and assessors be governed by the rules made by the rules board and or practice direction of the land court judge president and not by the regulations made by the minister. Chair, we are in support of this proposal. It is our view that the rules board is given the mandate to make rules for mediators and interpreters, and may better be placed to make rules for assessors as well. So we are considering that this is a suitable proposal that we can incorporate in the bill through the amendment. Chair, the Institute of Race Relations submits that the bill requires not more than 2 assessors may be appointed together with a single court judge who will normally preside. The bill is silent as to the qualification they must have and on what steps will be taken to ensure that only fit and proper persons are brought in as assessors. This is important because assessors become members of the court. They submit further that where 2 assessors are appointed in a case, they have the power to overrule the presiding judge on all questions of fact. It is our submission simply, Chair, that the regulations or the rules will provide for qualification for appointment of assessors. So this will essentially be covered by the regulations or the rules. It is further submitted that in very many instances, the dispute before the court will be on questions of fact, which inadequately qualified and potentially partisan assessor will be empowered to decide. They submit that this undermines the rule of law, the supremacy of which is guaranteed by Section 1C of the Constitution. It is also inconsistent with Section 34 of the Constitution, which gives everyone the right to have legal disputes decided by independent and impartial courts or similar tribunals. Chair, it is our submissions that the appointment of an assessor to the court does not make the court any less of a court, but the intention is to assist the court on the question of fact only. The parties are not deprived of the right of access to courts by the mere appointment of an assessor. We are submitting further, Chair, to say that to provide for assessors is permitted by Section 180 of the Constitution, which enables the national legislation to provide for matters concerning the administration of justice that are not dealt with in the Constitution. It is our submissions that the issue of assessors is sufficiently covered by the Section 180, which enables us to make provisions for assessors in the bill. It is further submitted that the clause makes a mockery of Section 174 of the Constitution and its demanding requirement for appointments to the bench. Assessors, Chair, are not appointed to the bench as judges. They are only appointed to assist or to sit in order to assist the court on a particular matter that will be before the court. Legal Resources Center submits that while the current formulation of the clause makes provision for the appointment of an assessor, it does not speak to the expertise that is required by the assessor. It is submitted that an assessor in the land court must have knowledge, expertise, or experience related to the claim that they are called upon to adjudicate. Chair, the regulations or the rules will set out the general provisions relating to the appointment of assessors. This will be covered in clause 36(1)(d) of the bill. This clause deals with regulations, and 1D specifically deal with the appointment of assessors. Socioeconomic Rights Institute proposes that amendments be made so that the appointment of assessors and the determination of their fees be removed from the executive control and placed under judicial control. Chair, the minister prescribes through the regulations or the rules the manner of appointment of assessors and their fees, but the presiding judge will choose the assessor or the assessors who will sit with in the court, and this will be made in accordance with the needs and the requirements of a particular matter that will be before the court. This has been a practice for a long time. It has been an established a process, and it does not interfere or hamper the independence of the judiciary. Chair Kwanalu submits that assessors as an aid to the courts are not widely used in South Africa. They are used in limited, they are limited to extreme cases. The origin of the use of assessors to support a case is based in specific technical case law, such as marine and digital litigation. They are not typically used in general, applied in the day-to-day litigation. In the case of land court, it is proposed that there will be, in the first instance, insufficient skilled and independent assessors to adequately support the office or the court, and B, that within South Africa, the assessor system is not structured in a way that sufficiently safeguards and promotes the effective adjudication of cases. Combined with this, Chair, it is submitted that clause 12 be removed from the bill in totality. They are submitted that although this omission will not entirely prevent the use of assessors, it will reflect the use of assessors on wider case law so that their use is consistent with the general application of the law in South Africa, rather than unique to the land courts. Chair, we note this submission, but we are not in support of it. The court is not obliged to use assessors in all the cases that will serve before it. The total deletion of this clause will deprive the court of the power to make use of assessors in cases where the use of assessors will be beneficial to the court and to the case and the parties before the court. The view that the assessors in land court matters will be insufficiently skilled is not supported when judging from the research done by the academy, the civil society, and several individuals, as the issue of land is a long-standing matter both in the Republic and abroad. Lamusa submit and propose for the insertion of the clause as subclause 7 to read: the judge president, when deciding a matter, when deciding that a matter is to be heard in court as contemplated in section 13(2)(a), direct that an assessor knowledgeable to the content of the relevant customary law be appointed to sit in the matter. Chair, it is our submission that the appointment of an assessor is, in terms of clause 12(4), is to assist the court on a question of fact and the court decide a question of law. It is our submission further that the power to appoint is given to the judge who will be hearing the matter and not the judge president. Therefore, the presiding judge will be in a better position, Chair, than the judge president to determine to make a determination on the need to use an assessor. Clause 13, Chair, deals with the institution of proceedings. Agri SA and Agri SA Mpumalanga submit that it will be impossible for the judge president to decide whether a matter should be referred to arbitration or mediation merely upon receipt of a notification from a claimant that proceedings will be instituted. The judge president will not be aware of what defenses will be raised by the defendants or respondents, or whether the matter will be defended at all. Referring the matter for arbitration or mediation without hearing the other side might well constitute a breach of the Odi Alteram Partem rule. Chair, it is noteworthy that this submission relates to the bill as it was before the portfolio committee. However, we have amended the bill in this regard. It is our submissions, Chair, that the procedure will be provided for in the rules of court. There will have been an exchange of documents in the process of litigation before the matter could be referred for mediation. That is, when there's been an exchange between the parties, then the matter will reach a stage where the judge president will be able to make a determination as to whether the matter should go for mediation or should go for court. As such, Chair, the provisions dealing with arbitration have been totally removed from the bill that is before the committee. It is further submitted that mediation, in contrast to arbitration, can be and should be ordered in suitable circumstances. However, mediation will not work if one or more of the parties are intractable in the positions that they have adopted and are unwillingly to deprive or to deviate therefrom. In such cases, mediation will be futile and the matter should be adjudicated by the court. Chair, a matter will be assessed by the judge president to determine if it is suitable for mediation or should be referred to the court. Chair, it is our submission further that although mediation is a voluntary process, if it is ordered by the court, it must be attended to. That is, if the court refers or the judge president refers the matter for mediation, the parties must attend to the mediation process. However, Chair, as contained in the bill, any party can request the mediator to refer the matter to the court for adjudication instead, if the other party is intractable or if the parties are not able to resolve the dispute before them. That is, Chair, the parties are not strictly confined to the mediation process. They are able to refer the matter to the court in certain instances if the matter can or should be referred to the court, particularly where the parties could not resolve their dispute, or if one of the parties are intractable, as suggested. Chair, furthermore, it is submitted that a hearing can only be allowed after the papers have been served on the defendant or respondent, after the pleadings have closed in an action, or all affidavits have been filed in the motion proceedings. The allocation of hearing dates should be subject to rules of the court and not be prescribed in the legislation or the regulation. Chair, as submitted before, there will have been an exchange of documents between the parties before the matter can be allocated a hearing date. The current version of the bill is clear that the procedure will be provided for in the rules of court in this regard. Clause 14 deals with rules governing the procedure of the court. AfriForum submits that the court should not operate on an informal basis. It is our submission, Chair, that there may be instances where it may be necessary for the court to conduct any part of the proceedings on an informal basis. The clause does not empower the court to conduct the process of adjudication on an informal basis in totality, but rather any part of the proceedings can be adjudicated on an informal basis. It is submitted by Agri SA Chair that the court should have its own rules. There is no provision in the bill for the judge president or anybody else to make rules for the court. Much of the land court's work will be peculiar to its functions as a specialist court and is not catered for in the uniform rules. Since the members of the rules board may not have had the requisite exposure to the work of the land court, the judge president of the land court may be better equipped to draft the rules, but subject to approval thereof by the rules board. As I've mentioned before, Chair, the rules board is mandated and empowered by clause 4 to make rules for the court. This is a statutorily established a body to make rules for the courts of the Republic, and it is our submission that the members of the board are capable of making rules for the land court as well. It is submitted that it might cause confusion if the court's procedure are subject to both the uniform rules and its own rules. There could, however, be a provision in the bill that the uniform rules will apply where the land court rules are silent on a particular issue. Chair, the court will have its own rules as designed and established by the rules board, and the uniform rules will only apply to the land court where the rules board has not made the provisions in the rules. That is, if there is a gap, then the reliance will be made to the uniform rules. It is further submitted, Chair, that the Superior Courts Act, the uniform rules, and the regulations which the minister might make do not cater for all procedures of the land court. The land court, it is submitted, Chair, which is also a specialist court, has its own rules tailored to its particular needs. The Land Claims Court also has its own rules, which can serve as a model in preparing rules for the land court. The Land Claims Court should, however, apply until such time as the land court rules have been promulgated. Chair, as mentioned before, the land court will have its own rules made by the rules board, and the uniform rules will apply where there is a gap. The intention is that the rules should be in place when the bill comes into operation. That is, Chair, as soon as the Land Courts Act comes into operation, then the rules should be ready for operation at that stage. And as a result, Chair, there's no need for the existing Land Claims Court rules to apply in the interim. It is further proposed that the Land Court should also authorize the Judge President of the court to issue practice directions from time to time as the circumstances may require. Chair, this is governed by Section 83 of the Superior Courts Act, which empowers the Chief Justice of the Republic to issue directives, but the Chief Justice can, in terms of Section 84 of the Superior Courts Act, delegate this power to any other judicial officer of the court concerned, including the Judge President. So in this regard, if the Judge President or if the Judge President deems it appropriate, the Judge President, the Chief Justice instead, can delegate this power to the Judge President of the court. The Institute of Race Relations submits that the bill undermines the established procedural rules by suggesting that the court need to follow only those rules that facilitate the expeditious handling of disputes and the minimization of costs. The established rules of procedure in the High Court have been developed over a very long time to help ensure that issues are properly heard and justice is done to both parties. It is our submission, Chair, that the Rules Board will, among others, develop the rules that are aimed at assisting the court in providing or implementing a fair and just approach when it comes to an inquisitorial system of adjudication as and when necessary. Legal Resources Center provides that the clause is extremely vague and unclear as to which rules of the High Courts will apply, and if so, how they will be changed to reflect the context of the Land Court. If the rules of the High Court are to be used, it must be made very clear which rules will apply and how they will apply to take into account the specific context of the land issues. Chair, it is our submissions that the aim of the provision is that whilst the Rules Board will make all the rules for the Land Court, if the rules do not cover a certain aspect of the process, then the court, that is the Land Court, can simply apply the existing uniform rules in those particular circumstances, obviously then adapting them to suit the Land Court as it will be facing a land dispute. It is submitted, Chair, that the bill does not cover a power or does not confer, I beg your pardon, a power on the Land Court to make its own rules, and therefore, where the High Court rules are insufficient or has to be changed for the Land Court, there is no provision allowing for the court to make those rules. Chair, the power to make rules is conferred upon the Rules Board. If the Rules Board are insufficient to cover certain aspects, then the court will use its inherent powers as contained in clause 3(2)(a) of the bill itself. It is submitted further, Chair, that where there is concurrent jurisdiction with the Magistrate Court, it is unclear which set of rules will apply: the High Court rules, the amended Land Court rules, or the Magistrate Court rules. Chair, it is our submissions that a matter before the Magistrate Court will ordinarily follow the Magistrate Court rules, and the Land Court will apply its rules, which will be developed by the Rules Board. And in cases where these rules are insufficient or there is a gap there, the uniform rules will be applicable and applied by the court. The Land Claims Court rules, which are currently in place, will be repealed by the rules that will be developed for the Land Court. It is further submitted, Chair, that the rules of the Land Claims Court should be retained and amended to reflect any changes in the bill, but should continue to form the backbone of the procedures in the Land Court. It has been tailored specifically for cases related to land, and they work effectively and they are easy to navigate. It is stressed that court procedures should be kept as simplified and easily accessible as possible. Chair, it is our anticipation that some or most of the Land Court rules that currently are in operation will be retained so as to not reinvent the wheel. However, Chair, this position is basically anticipatory because we cannot dictate upon the rules in terms of how they are going to develop the rules. It is therefore the Rules Board prerogative to decide how these rules should be drafted. Chair, can I pause at this stage to check if I can still be heard?
Yes, you can, and all members are still on the platform. Some are having challenges with network, but I suspect that they have come back on. Okay, but I do see the hand of Honorable Dodovu. Honorable Dodovu, do you have?
No, I see it's a mistake.
Okay.
Chair. No,
All right. No. Mr. Mokolo-Bete, we are with you. Please continue.
Okay. No, thank you very much. You know, it happens that maybe I'm still speaking only to find that I've already been kicked out of the meeting. But thanks to hear that I'm still with the committee. Chair, continuing with the submission by the Free State Agriculture, they submit that the bill should authorize the Judge President of the Court to issue practice directions from time to time and when circumstances may require. I've made reference to Section 8.3, Chair, of the Superior Courts Act, which empowers the Chief Justice to develop the directives for the High Courts. So this power is given to the Chief Justice, who in any event can be able to delegate it in terms of Section 8.4 to the Judge President. The Land Claims Court Chair submits and proposes that Clause 14.1 be amended to read, except as is otherwise provided for in this Act, the provisions of the Land Claims Court rules promulgated under Section 32 of the Restitution of Land Rights Act 22 of 1994, and where such rules are silent, the provisions of the Supreme Court Act and of the rules regulating the conduct of the proceedings in the several provincial and local divisions of the High Court of South Africa, made under the Rules Board for Courts of Law 1985, apply with the necessary changes required by the context to the court insofar as these provisions relate to the various aspects. Chair, we are not in support of this proposal. It is our submission that the Rules Board will make the rules, and which rules will replace the existing Land Claims Court rules. However, we are suggesting a certain insertion in the clause after the words relating to, which reads the court processes including. We will in due course, Chair, address this further in detail. And this insertion will ensure that the rules to be developed by the Rules Board are not restricted to the listed item. Chair, coming to those listed items, these are the items which are currently listed in the bill itself. However, going to paragraph B of the submission, the Land Claims Court submits proposes the insertion of subclause 5 to read: the President of the Court may make rules to govern the procedure of the court, including rules providing for, and then they've got A, B, C up until D, which are the proposals that they are proposing for insertion in the bill. Which proposals we are not in support of, because the intention is to ensure that the Rules Board will make the rules for the Land Court. Dealing with paragraph A that they are suggesting, which says any matters listed in paragraphs A to S of subsection 1 of section 6 of the Rules Board for Courts of Law Act, insofar as they are appropriate to the functions of the court. Chair, the Rules Board has the general power to make rules in terms of those paragraphs A to S of the Rules Board Act. So this is the general empowering section, that is section 1, in terms of which the Rules Board can make the rules for the courts. So we are not in support of this this insertion, Chair, because the Rules Board already, in terms of the Rules Board Act, has the power to make rules in terms of those paragraphs. Chair, the submission further goes on to propose for the insertion of the circumstances under which opinion and oral evidence may be submitted to the court. This is covered by clause 14(1)(a) of the bill. The suspension or execution of judgment, orders, or sentences of the court pending 1, application or petitions for leave to appeal, and 2, the prosecution of appeals. Chair, this is covered by clause 14(1)(b) of the bill, except that the proposal is to break it down. This Roman figure 1 and 2 are the provisions that are currently in the clause itself, that is clause 14(1)(b), except that in the bill we have them as one paragraph. However, the proposal is to break them down in terms of paragraph Roman figure 1 and 2, which we are not in support of. The clause is suitable and preferable the way it stands without breaking it down as suggested. It's furthermore, Chair, suggested the practice and procedure of the court in applications in terms of chapter 3, capital A. Chair, this is the proposal that we accept and we support, because it is a proposal to reinstate section 32(1)(c) capital A of the Restitution Act. Chair, we will consider the inclusion of this section 32(1)(ca) in clause 14, and it will be contained in 14(1)(d), so as to read the practice and procedure of the court in application in terms of chapter 3, capital A of the Restitution Act. So as a result of this, there will be a change in the numbering of clause 14, subclause 1. So in terms of the current paragraph D becoming a paragraph E. Chair, in short, this chapter that we are going to insert or to make reference to deal with the issue of direct access to the court, because it requires that the rules be made for the practice and procedure for the applications to be made for direct access to the court. So that will be the amendment to be made in the bill as it currently stands. Chair, there's a provision that says generally any matter which may be necessary or useful to be prescribed for the proper dispatch and conduct of the functions of the court. Chair, this is covered by clause 14(1)(d). Chair, it is further proposed the rules contemplated in subsection 1 shall be published in the Gazette. Chair, we are not in support of this because section 6(4) of the Rules Board Act requires that any rule made by the Rules Board be gazetted at least 1 month before it comes into operation. As a result, Chair, it is not necessary to insert this provision in the bill, as it is covered by the Rules Board Act under section 6(4). Chair, furthermore, it is proposed the insertion of a clause which will read, notwithstanding anything to the contrary in this act or in the rules contemplated in subsection 1, the court may at any stage after a claim has been referred to it, refer the claim back to the commission with directives as to matters which are to be investigated and reported on by the Commission. Chair, here the commission that is being referred to is the commission established under the Restitution Act, that is the Restitution Commission. Restitution of Claims Commission. Chair, this is furthermore one of the proposals that we are accepting, and we will consider for inclusion to substitute the current clause 14.2 so as to read, notwithstanding anything to the contrary in this act or in the rules contemplated in subsection 1. A, the court may, at any stage after a claim has been referred to it, refer the claim back to the Commission with directives as to the matters which are to be investigated and reported on by the Commission. And B, the court may conduct any part of the proceedings on an informal or inquisitorial basis. Chair, clause 15 deals with power and functions.
Mr. Makulubete?
Yes, Chair.
My apologies and to interrupt.
Yes, Chair.
Because I didn't want to interfere with the flow of your presentation.
Yes.
But I should just maybe indicate that we currently, I think, halfway through your presentation now.
Yes, indeed.
But maybe also to indicate to yourself that we as members of the committee as well, we had received the document well in advance. But is there any way that perhaps you could maybe summarize some of the issues, so that we could get through your presentation a bit quicker?
Yes, I'm sure I can try to do that. Instead of going through the entire presentation, I can do that, Chair. It's not a problem.
Okay.
Although I did not prepare that way, but I will do my best to do that.
Okay, I just wanted to alert you to the fact that we as members have received the documentation, and to a large extent we've been through the presentation, but notwithstanding the fact that I think some of you do add in terms of some of your explanations that you give, which is also very helpful. Please
Yes.
continue.
Okay, I will do that. Thank you, Chair, for the direction. Chair, in terms of the powers, there is a submission that the powers of the court and the function should be consolidated and included in the bill. Chair, it is our submission that this should not be the case. Each piece of legislation will set out the powers that relates to that specific piece of legislation, and the court will have to take into account the powers that it has under that piece of legislation when dealing with a matter that is before it. So it will not be necessary for the powers of each and every piece of legislation to be contained in the bill itself. Chair, legal resources, they are raising the uncertainty as to the clause that deals with the powers of the court. The aim of the provision that is this clause is to essentially say that the court will have those powers as contained in the various pieces of legislation that govern the dispute that is before the court. Chair, the intervention of proceedings before the court, the right to appear and legal representation is contained in clause 16. AfriForum objects to clause 2. They submit that the parties are equal before the law, and the court should not be allowed an automatic right to intervene. Chair, it is our submission that the state does not have an exclusive right to appear. The state should have the lucus standi, like all other parties before the court, to be able to be involved in the proceedings before the court. So the issue of lucus standi is key. The issue of whether legal aid has resources, Chair, we anticipate that because of the workload that is going to be given to the Legal Aid South Africa, then they will be required to provide sufficient personnel. I would like to pause here to give an explanation as to this issue of the land rights management facility. It's a facility that is established by the Department of Agriculture, Land Reform and Rural Development. This facility is given an annual budget, and this budget is used for the provision of legal aid to the indigent. Now, as the matters stand, there has been a transfer of this of the powers of the land rights management facility to legal aid. So that power of providing legal aid is taken away from the land rights management facility and is given to legal aid. So it means therefore that legal aid will have extra load of work in relation to land matters that will have initially been dealt with by the land rights management facility, which had its own panel of attorneys to deal with litigation in relation to land matters. And now those matters are going now to be dealt with by Legal Aid South Africa. So just to give a context is to say that as to the issue of the capacity, legal aid will be required to have sufficient personnel to deal with the extra load. Chair, this issue deals with that as well. There was an issue of the requirement of substantial injustice. Chair, this is one of the requirements that Legal Aid South Africa Act requires when the indigent person applies for legal aid. So the challenge was that it will be a strict requirement for an indigent to comply with. However, our submission is that this requirement has been there. It's not a requirement that is being or introduced by us in the bill. The issue of legal representation is raised also by Lamosa to say that the parties will not be able to do the paperwork before they go to court, because now they will have to have the matter before the court before they can apply for legal representation. However, Chair, it is our submission that is not the case. Any party qualify for legal representation even before the matter has been instituted in court. That is, a party who requires a legal representation can, before they commence proceedings, they can simply go to a legal aid to apply for legal aid. And if it is given, the legal aid officials will be able to assist with the drafting of the papers and for the issuing thereof in court. There's the proposal by Lamosa also of the insertion of a proviso, which submit is covered by section 16.4a of the bill, because it will be in the interest of a party to be legally represented in cases where they are not able to present their cases, in cases where the case is complex. And it stands to reason, Chair, that most, or if not all of the cases that are land related will be complex, and any party before the court in relation to that land matter will essentially have to be legally represented so as to ensure that justice is maintained. Chair, clause 17 deals with the power of the court to hear appeals. There's a submission that the clause 17 is redundant. However, it is our submission that the version of the bill reinstate the jurisdiction of the magistrate court. I believe the submission relates to essentially the bill as it stood before the portfolio committee. However, we have reinstated because the bill as it stood before the portfolio committee was taking away the jurisdiction of the magistrate court totally when it comes to the dealing with land matters. However, the bill before this committee reinstate the jurisdiction of the magistrate courts. Therefore, the land court and the magistrate court will have jurisdiction in relation to certain matters that will be before the court. Chair, the review of procedures, the section 2021 deals with the review of the proceedings of the magistrate court, so that that section will be applicable there. Admissibility of evidence. There is a submission that it remains challenging to adjudicate on the credibility of the admissibility of evidence. Chair,
that wasn't me. I think Miss Charlie, she's unmuted. I'm not sure if Gashwani could mute her, or if she could mute herself. Emily Charlie on the platform. Okay, thanks. Please continue, Mr. Mokulube.
Thank you very much, Chair. Chair, the admissibility of hearsay evidence will be determined by the court, and the court will check the weight thereof, because the evidence before the court must be cogent and must be weighty. So the court will determine the weight of the evidence as to whether it can be acceptable, because the intention is to make sure that the court does not strictly apply the rules of evidence in instances of especially the restitution of land rights. Then there will be some sort of flexibility in the admission of hearsay evidence. This issue talks, Institute of Race Relations also deals with the issue of admissibility of evidence. However, the hearsay evidence is dealt with in the bill only in relation to the matters that are emanating from the restitution of land rights. Other matters, evidence will be dealt with and admitted by the court in terms of the applicable law of Evidence Amendment Act. Chair, the criteria we have mentioned, the cogency is the main issue that the court should consider, and the weight of the evidence that needs to be considered by the court. There's a provision or proposal to redraft this clause. However, it is our submission that this clause exists in the Restitution Act, and we just took it from there and then inserted in the bill as it is. Clause 24 deals with the powers of the court. There's a challenge to section 24 in terms of which a question of law can be referred to the Court of Appeal. Chair, this clause or this section exists in section 158(4) of the labor relation. So we are not coming up with a new proposal here. It is there, and then it works well in practice, and then it is better that we have it instead of having the issue disputed or dealt with in the land court. It can just be reserved for adjudication directly by the Supreme Court of Appeal. Chair, the issue of incidental, I have dealt with that. Section 24(1)(c) enables the court to be able to deal with the matters that are incidental to the matter before the court. However, there is a suggestion of a technical nature which we are not in support of because the clause as it is sufficient and it serves the purposes that is intended for. Chair Lamusa, there's a provision that is made there. Basically, there is a submission to include various pieces of legislation under the immediate jurisdiction of the court. For instance, the Mineral and Petroleum Resources Development Act is one of the pieces of legislation that is not placed in the jurisdiction of the court. As I've mentioned before, we do not want to inundate the court unnecessarily, especially when it is so newly established. We want to start with a 9 pieces of legislation for immediate placement under the jurisdiction of the court, and then there will be an incremental approach in terms of which these other pieces of legislation can later be placed under the jurisdiction of the court. Chair, there was a proposal to have the customary law be inserted. We do not support that. A customary law is presented by way of evidence where it is necessary. Retail conferences, Chair, there's a proposal by the Land Claims Court. Chair will have noticed that maybe it could be the 3rd or the 4th proposal of the Land Claims Court that we are accepting, and we will filter it in the bill by way of an amendment. The court orders, there's a proposal that these paragraphs must be replaced by a clause stating that the court may make an appropriate order which a high court is competent to make. This proposal, Chair, is covered by the current bill as it stands, and it's not necessary for us to make any changes in relation thereto. Chair, furthermore, the proposal by the Land Claims Court, the insertion of subclause 10, we are in support of that insertion. Furthermore, this one, clause 35, clause 27, to make a reference to section 3511, and we are in support of this proposal, and it will be factored in. Chair, there was an issue of the when it comes to costs that is dealt with under clause 28, the issue of fairness. It is our submissions that when the court makes an order of costs, it must consider the requirements of law and the fairness. Chair, the submission of Agri SA in relation to clause 28 2B is that it should be deleted. We are in disagreement because we believe that that clause is necessary, as it requires the court to consider if an unfounded action or an unsustainable defense has been put up. That is, the court can be able to penalize a party if they came up with an unfounded case or an unfounded defense. Chair, the issue of penalizing a person who represented a party before the court, the court is given this power to penalize even a representative of the party in conducting the matter. So normally the court will award a cost order against a party to the proceedings. However, in deserving instances, the court is empowered to penalize a person who is representing a party before the court. Chair, the issue of fairness, I've dealt with it. It is necessary that the law and fairness be considered when the court considers the issue of costs. This also deals with the question of fairness, the punitive costs order against an attorney acting against a party. The court is empowered to do that. The Stalingrad tactics, it is proposed that we should make a provision for the bill to specifically penalize a party who come along with a Stalingrad tactics. Chair, we believe that we do not need to specify this because the court will be in a better position to determine if there have been any Stalingrad tactics employed by the party, and the court can be able to make a punitive cost order in relation to that. Chair, the issue of transfer of matters, I did talk to that when a submission was raised in relation to the transfer of matter. The proposal is to enable the registrar to retain the court file and make copies of the relevant documents when the matter is transferred to the mediator. What is going to happen is that if the matter is to go to the mediator, the clerk of the court is going to make copies and then submit those to the mediator, and then retain the original court documents, because Chair, the matter can come back to the court either through a settlement, in terms of which the matter will be made, or the settlement agreement between the parties can be made an order of court, or if the parties could not be able to settle their disputes, the matter can be transferred back to the court, where it will proceed with the original documents before the court. The clause relating to the fees for the mediators will be dealt with in the rules. The rules board will make the rules that will deal with the fees and disbursement for the mediator after having been appointed by the parties. The minister, Chair, currently has got the power to determine remuneration of mediators. This has been a long practice, and the submission was to remove the power from essentially the minister to making provisions for the remuneration of the mediators. Chair, this talks to the voluntariness of the mediation process. The parties are able to decide to mediate, or if they want to go to the full-blown litigation, they are able to do that. However, the bill enables the party to make that decision whether to go for mediation, even after the matter has been commenced before the court. Chair, this clause, the reference to the mediation, the bottom line is that when the parties come to a settlement, they will be able to make a decision as to who will be liable to refund the fees that will have been paid for mediators. And if the matter goes to court, then the court will make a determination as to who is liable for the payment of the cost for the mediator. Chair Lamusa they make a proposal, a submission in relation to clause 29.2. They are submitting that what is missing in this clause, which cannot be cured by regulations or the rules, are that specific provisions to enhance the legitimacy and status of mediation and ensuring that the mediation process and progress is monitored by the land court. Chair, we do not intend to see the court being involved in the mediation process, except when the mediation is ordered by the court, and when the matter comes back to the court, if the parties have reached the settlement, then the matter can come back to court, and that's when the court will be involved in the mediation. However, the court should not monitor the progress and processes of mediation as proposed by the role player in this regard. There are certain proposals that we are not in support of, and then here, Chair, we explain to what extent we are not in support of those submissions. There's a proposal that is also covered by the section 38(1) of the Superior Courts Act, which is not necessary for inclusion in this bill. The proposal for the officers of the Land Claims Court is an interim or a transitional provision that the officers who are appointed should continue to become officers and staff of the court. We are not in support of this. The normal protocols that exists in the High Court will be followed in terms of the appointment of the staff of the court. There's a proposal also by the Land Claims Court relating to clause 34, and we are in support of this proposal, and we will consider including it in the bill by way of an amendment. Chair, the amendment of laws, the issue of the bill containing only 9 acts to give the magistrate court and the land court concurrent jurisdiction. I have indicated before that we are adopting an incremental approach in terms of which only 9 pieces of legislation are going to be inserted in the bill, because we have, as I've briefed the committee on the 12th of October, identified about 33 pieces of legislation that are land related, and which obviously we have excluded from the bill. These are pieces of legislation can be included and placed under the jurisdiction of the land court in due course by way of an amendment in those particular pieces of legislation, and the amendment is not going to happen in the bill itself. It's going to be done in those pieces of legislation in terms of which the amendment will be made to the definition of the court to make reference to the land court or the magistrate court in certain instances. So in a nutshell, Chair, this is seemingly a big issue because many people are of the view that the land court should immediately deal with all land related matters. The submission, we do note that, but we do not want to overburden the court, especially when it operates for the first time. Hence, we are taking it slow in terms of giving it a certain number of legislation to deal with. Chair, the regulations are dealt with in terms of clause 36. There's a concern with the provisions that are inserted there. It is stated that they are too wide, extremely wide, and will enable the minister to interfere with those. Chair, the minister is empowered generally in all legislation to make regulations. And these regulations are the necessary regulations that needs to be made in relation to the bill itself. And these are not new inventions. They are necessary and the standard provisions that will normally be found in other pieces of legislation. Chair, the necessity of specifying the criteria for the appointment of assessors, this will be covered by the regulations or the rules, and it's not included in the bill and will not be included in the bill as suggested. Chair, there's a proposal by Lamosa for insertion of or addition of these sub-clauses 3 and 4 in clause 37. And we are not in support of those provisions because they will dilute the power of the president to determine the commencement date of the act once the act has been signed into law. This is a repetition of the issue that have been raising, that we are confining ourselves to only 9 pieces of legislation so as to not inundate the court. The Land Claims Court has got various propositions, some of which are not supported, but we are supporting this insertion because it talks to the rules and regulations that have to be made, and we will consider including this proposal when we do the amendment to the bill. Similarly, this proposal, an audit to ensure that everything that's needs to be going over to the bill from the Restitution Act has been carried over. We have done this inventory check or audit to check each and every provision that needs to be included into the bill being taken from the Restitution Act. Chair, there will be concurrent jurisdiction between the Land Court and the Magistrate Court in as far as the PI evictions matters are concerned. The issue of the capacity of taking away the Land Claims Court matters to the Land Court, to the exclusion of the matters that are dealt with in the High Court. All those matters will have to be dealt with in the, that is all PI Act matters that have been dealt with by the High Court are now going to be dealt with in the Land Court, and this will talk to the caseload, because now it will have many matters to deal with. However, there's a criteria for the capacitation of the judges, together with staff, of course, of the Land Court, when the appointments of the judges and the staff of the court are considered. Chair, I've mentioned the court is in Joburg. We are retaining the sitting of the court as it is with other sittings, where in terms and in terms of clause 7.3, then the sittings of the court can be held elsewhere other than in the main seat of the court. Chair, the powers of the minister to make the determination of the sittings of the court. This will obviously be dealt with in consultation with the judge president. However, the judge president can be able to decide and make a determination as to where a particular matter will be held. Chair, remember when I did the briefing on the 12th of October, we submitted that the intention is to make sure that the courts can be accessible to the parties. We have rural areas which are far away from the cities and the courts. As a result, then the judge president can be able to determine an area, a closer area to the community, for instance, a town hall or even a school can be able to be used in terms of this clause for the sitting of the court in that particular city hall or the school. Obviously, then it will be capacitated in terms of the equipment and the staff, so that the court can be held at that particular community instead of the court being held elsewhere, far away from the communities. Chair, this issue also talked once again to the jurisdiction of the magistrate court. I think we have dealt with that. And the Chair, as I've mentioned, we have two tables. This table 2 deals with a general comments which do not go to the specific process of the bill, and we have given a substantive responses in respect of each and every one of those submissions. And I believe, as Chair has mentioned, it may not be necessary for me to deal with them, except one last point, Chair, that deals with the tagging of the bill. We have received a submission from Gelden Cilliers and Gelden Hayes attorneys, together with the Institute of Race Relations. These attorneys have made their own submissions as representative of Institute of Race Relations. However, Institute of Race Relations has also submitted their own proposal in relation to this issue. Chair, in short, they are of the view that the bill has been erroneously tagged as a Section 75 bill, and it must be instead classified as a Section 76 bill. They have raised various issues in support of their submission to advocate for the conversion of the tagging of the bill from a Section 75 to a Section 76. However, Chair, our submission in relation to the tagging is that when we processed the bill, we were of the view that it should be processed as a Section 75 bill. The intention of the bill, Chair, the bill does not deal with the substance of land. Land is a big issue. It is a substantive, and it is dealt with in various pieces of legislation, and we have isolated 33 of those. However, this bill does not deal with the substantive issues relating to land. It only establishes or creates a court where the disputes emanating from those pieces of legislation are going to be adjudicated. So basically we are saying, here is the court where those pieces of legislation are going to be adjudicated upon. The court or the establishment of a court is not a matter that falls within the ambit of the provinces. It is not the court are actually the mechanism for the administration of justice. And this is not an issue of a provincial competence. Even though the bill amends those pieces of legislation, the amendments that we are effecting there are to take away the High Court and then replace that with the Land Court. And it is our submission that this is essentially a technical amendment. Hence, we are doing it in the bill. And hence, we are of the view that because of that very technical amendment to the various pieces of legislation, the bill does not enter the terrain of a provincial competence to an extent that the bill has to be tagged as a Section 76 bill. We are making a reference, Chair, to the Tugwane judgment, where essentially, Chair, it is stated there. If what the court has to consider, maybe if this bill has to be before the court will have to check whether the provisions of the bill in a substantial measure fall within the functional areas listed in Schedule 4. As I've mentioned, the establishment of court is a functional area that deals with the administration of the justice, which is not a matter which falls under the functional area of the provinces. And it is therefore our submissions that this bill is correctly tagged as a Section 75 bill. And the Chief State Law Advisors were concurring with our submission that the bill be tagged as a Section 75. However, Chair, as I understand that the Parliamentary Legal Services will be perhaps given a platform to address this issue in detail. However, it is still our submissions that the bill should still be tagged as a Section 75 bill. Chair, this brings me to the conclusion of my presentation. And I see that I've taken too long, and for that I do apologize. And will be in the hands of the chair and the committee in terms of maybe then the taking of the questions. Thank you.
Thank you very much, Mr. Mokulubete, for that lengthy, but if I may say, rather necessary presentation to the committee. Honourable members, I think as Mr. Mokulubete closed off, he did mention the issue of the tagging of the bill. I'm going to propose, honourable members, that we note what was presented on that matter. But in the next meeting, we'll also get the parliamentary legal advisor to clarify this aspect as well for the committee. So while I open it up for any comments and or questions for clarity from members, I just want you to bear that in mind. And I want you to request that maybe if you have questions around the taking, if we could just hold on to those for the next meeting. With that said, on members, can I open up the platform and get an indication from yourselves if you have any questions for clarity and or comment that you would want to make. If you could please give me an indication. Okay, I'm not picking up any member. Okay, I know Honorable Dodovo. Honorable Bartlett, are you still on the platform? Because I know you've been having problems with your network. Honorable Dodovo, perhaps if you could kick off for now. Honorable Dodovo.
Yes. Thank you very much, Honorable Chair. And thank you very much for the presentation. As you pointed out, it was a very long presentation, but extremely necessary. And what the presenter has done is quite marvelous, because this is what we are expected to do as Parliament, to carefully consider all the submissions which were made before us, so that we understand quite clearly what is it that these organizations and individuals are saying in respect of this lawmaking process. I think, Honorable Chair, this is quite important. What excites me is the fact that this bill itself has attracted a lot of interest across the broader spectrum, and even the number of submissions that were received, it does indicate that people are very much interested. They are concerned, and they want to ensure that they make the necessary inputs. I think as members of Parliament, we must take all the inputs very serious, consider them, think deep about them, and see what is it that we can do to ensure that at the end of the day, this land court bill, once it is passed and implemented, especially the establishment of the land court and the land appeals court, we assist that process to be firm, to be properly rooted, and therefore accomplish its objectives on a matter that it is very, very much contentious, a matter that is very, very close to the hearts and minds of our people. That is the issue of the land. And I think we need to do that. Now, Chair, I don't have a specific question, but rather a guidance from you that I'm requesting that you must, based on this, guide us in terms of how do you want us to unfold the process and consider all the submissions made that we have received as a committee, so that as we process it, we know what is it that these people have said, and we know and understand what is the responses from the department and what is our view in respect of each and every submission that was made. Just one point, Honorable Chair, is that I see both substantive issues that are raised, broadly speaking, in the submissions that were made. But at the same time, I also see some technical and really not necessary issues which were raised. And on that score, I want to say that we must not be derailed, we must not be defocused, we must stick to what we need to do, because in the final analysis, this process must be concluded, it must be expedited, and at the end of the day, we need to assist quite helpfully to ensure that this piece of land, this piece of legislation the establishment of the land court is accomplished. And my express view is that we must look at that. In short, I'm saying that please just give us a guidance in terms of how you want us to crunch the submissions as made and take the process forward. My view is that we may not conclude the whole process now, today, or in the nearest meeting. We need to take our time to really look at all the specific issues so that as part of lawmaking process, we are sure that this law is firm, is lawful, and at the end of the day, benefit the South African people as it should. Thank you very much, Honorable Chair.
Thank you very much, Honorable Dodo, for the comments and all your suggestions. Let me take Honorable Bartlett and then I'll come in thereafter. Honorable Bartlett.
Thank you very much, Chair. Sorry for not switching on my video, Chair. Chair, just have 2 questions on the land court presentation. Am I audible, Chair?
Yes, you are. Please continue.
Yes. Firstly, Chair, we know that appointment and competency of judges in the land court has been raised consistency in the submissions. Although the department has responded to the specific submissions, it may benefit the committee if the department can elaborate on this. And then secondly, Chair, we also know that the role and competency of assessors in the land court has been raised in several submissions. Can the department provide further clarity on this? Thank you, Honorable Chairperson.
Thank you very much, Honorable Bartlett, for the two questions. Maybe just from my side as well, and perhaps it is a matter that we should have also raised in our previous meeting with the department, and it also comes out of the research documents that members or utilized as well in preparation for the meeting. And perhaps on the issues I raised, if the department can respond, I think it would be appropriate. But if not, I mean, we can always still deal with the matter in the next meeting. The first issue is with regard to clause 26 and relates to the removal of the arbitration clause. I think if we go back to the bill, clause 26(1)(g) refers to arbitration awards. It still refers to arbitration awards. And perhaps maybe the department can clarify whether this is a possible amendment that should be made in order to delete the reference to arbitration awards. That's the one issue. The second one relates to clause 29, and I think this also comes out of the A list, where the phrase that was inserted after line 16, in terms of which the court may, on application of any affected party or in cases falling under paragraph B, acting of its own accord. This amendment does not appear in clause 29 in the B version of the bill, and maybe the department can either clarify this and or respond to us perhaps in the next meeting. I think with that said, let me get the responses from the department on the matters, but maybe also to comment on Honorable Dodo's issue is that, I mean, this is not the final platform where we want to finalize the bill. It's continuous in terms of the engagement, but I think what the department has presented are the responses to the comments that the public had made. And I think it clarifies some of the matters as well for us. But obviously in the next meeting as well, we will continue with some kind of deliberation on the one hand. But on the other hand, I think Honorable Dodo, we also proposing that, you know, the urgency of the legislation as well. And that is also a matter that we'll try and balance as we move forward on that. Let me hand over then to the department. Can you maybe perhaps respond to the 4 issues?
Yes, thank you very much, Chair. I appreciate the platform to respond to the questions. Chair, I'm going to deal with the questions that have been raised, and I'm going to ask the Chair to, if acceptable, hand over to my colleague, Mr. Dupree, to maybe then give the committee an indication as to maybe then the further processing of the bill, if that is acceptable to the committee. Chair, the clause that you're referring to in clause 29, I will request that we deal with that at the next meeting, because it seems to be a very serious issue that we will want to apply our mind to properly, so that we can be able to give the committee an appropriate and a substantial response to, if that will be acceptable. And the issue of clause 26 and arbitration, the previous bill, as I've mentioned, Chair, did have the provision for arbitration and mediation as alternative manners of dealing with, or as alternative dispute resolution measures. We have taken out the arbitration provisions because many of the submissions that we have received at that stage were not in support of arbitration. Hence, we took it out. But now, it does not mean the parties. It does not mean the parties cannot avail themselves to the arbitration process. Parties can be able to arbitrate the matters, but it will not be a court-ordered arbitration like it is the case with the court-ordered mediation. So the parties, when they have a dispute, instead of going directly to court, they can be able to undergo an arbitration process. It can be through the various pieces of legislation, the 33 pieces of legislation. If those pieces of legislation have got a provision permitting arbitration, then they can do the arbitration. Alternatively, the parties can use the Arbitration Act as the legislation that they can use to arbitrate on the matter before they go to court. However, the clause that the chair referred to in clause 26(1), which says the court may make an appropriate order, including making an arbitration award or any settlement agreement an order of the court. Chair, what we have here, it will seem a mistake to have arbitration there, but it is not. We have it there on papers to cover the instances where the parties have, before they went to court, they can go to the court so as to make their dispute or their arbitration award subject to the settlement of the court. So in terms of the arbitration award, if the parties agree, it can be made an order of court. That is what we have in mind. And this is not a compulsory process that the parties must undergo. It will be an election from the parties as to whether they want their award to be made an order of court or not. Because obviously an arbitration award, it is an award that can be executed upon. Hence, I'm saying it is not necessary for it to be dealt with or to be made an order of court. It's also only dependent on the election of the parties. Chair, the The issue of the appointment of judges. Yeah, the honorable member, Honorable Bartlett, is correct to say that it featured quite a lot in the submissions that we have received, and it is contained, or it is dealt with by clause 8 of the bill. It is the clause that we have designed to deal with the appointment of judges, and ultimately the president is the authority who makes the appointment of judges. And obviously, this appointment is made after the president has obtained an advice from the Judicial Service Commission, and the processes that are currently being followed by the Judicial Service Commission will still continue in terms of making a determination for the suitability of a candidate for appointment to the bench of the land court. So what is going to happen is that the candidate who will want to be appointed to the land court will follow the same processes, will follow the same robust engagement with the Judicial Service Commission. And if that candidate is not currently a judge, then our understanding is that, or the anticipation is that that candidate will be appointed a judge and then immediately appointed or deployed to the bench of the land court. Obviously, then the commission will at that stage have considered and explored the suitability of that candidate in terms of the expertise and experience on land rights matters. So we have established that standard specifically for the appointment to the land court, because that standard does not, and obviously will not apply to the appointment to the High Court. So yeah, the important thing is that there will be appointment of the candidate to being a judge, and then deployment to the land court. However, if the judge is already a judge, then there will be a deployment directly to the land court. Chair, the issue of race and gender was a central issue amongst those issues that were raised relating to the appointment. As I've mentioned in my briefing, this is a constitutionally mandated provision. It's a requirement from the Constitution itself as one of the parameters that must be considered, that is race and gender, must be considered on a candidate when the placement is made to the land court. Chair, these are the questions that I have picked up. I apologize if I've not picked any other, but I'm willing to deal with any if I've missed that one. And as I have requested the chair to give over to, if the chair will permit, to give over to my colleague as to how this process will unfold, because now, normally what we will do, we'll do this briefing, and then the next meeting we will, and chair, I'm not dictating to the committee as to how it should be followed, but I'm raising what we have.
If I may interject, Mr. Mokulubete, I think that's a matter that the committee would deals with generally as we process the legislation. It's not necessary for the department to give us a response on that.
Oh, okay, no, that's fine, Chair. Thank you.
Are you done?
Yes, I'm done with that. Then, Chair, we don't need to have Mr. Dupré, unless if he has to, he has something to add on my responses if any at all. But I am done with my responses. Thank you, Chair.
Thank you very much, Mr. Dupree.
Thank you, Madam Chair. I just wanted to inquire whether the parliamentary law advisors have submitted or made a written submission to you, or will it only be an oral response at the next meeting?
Are you referring to the tagging of the bill?
That is correct, Chair. If there is a written submission to the committee, I wonder whether we would be able to possibly request a copy thereof before the next meeting, Chair.
Okay. All right. Now that's largely logistics, but be that as it may, I think as I've indicated that in the next meeting, the Parliamentary Legal Services will make a presentation to the committee with regard to the tagging of the bill, and I think it's practice as well, because in as much as the department might propose that a bill be tagged in a certain way, Parliament also has its own assessment that it does in terms of the tagging as well, and I think the joint, I think the presentation by Parliament will actually, or the Parliamentary Legal Services will actually assist this process, and thereafter members of the committee will continue to engage on that matter. So for now, we've kind of just held it in abeyance till we get the presentation, and then we'll deal with that matter. I think the other issue is with regard to clause 29, which I think Mr. Mukulubete, you said that you will. It said that you will then respond to that in our next meeting. So we'll also hold that furthermore in abeyance. And then, but let me also thank the department. I think, you know, for your responses to all the submissions that were made by interested and affected parties on the land court bill. Like I said, in our next meeting, we will get the presentation by Parliament Legal Services, but also committee members would further deliberate and engage on what has also been presented in terms of today's presentation. And I know it was pretty lengthy, honourable members, but we won't stop the deliberation and engagement on the matters raised. But I think what we should also do to ensure that there's also some kind of balance in terms of our engagement and in terms of moving forward also with the processes, we should also take note of the fact that in terms of what was presented, there are proposals that have been supported, and these proposals are linked to clauses 8, clause 12, clause 14. There's clause 25, 26, 27, 34, as well as item 4 and item 3 of the schedule. And I think that these are things that I would propose, honourable members, that the Parliamentary Legal Services together with the legal teams in the department and the Office of the State Law Advisor perhaps also have an engagement on those matters. So that we just try and balance some of the processes and ensure that we don't have to be waiting on certain processes to unfold, and that as we get to our next meeting, and I think as Honourable Godoy said, that the bill, I mean the urgency of the matters that the bill deals with, and how it impacts on society is also an important thing. So we'll try and balance all of these processes to ensure that at the end of the day, we go through a very thorough process and to ensure that we have a bill in front of us. I think with that said, let me thank the department, and maybe also release yourselves, because we have actually a second agenda item that we're going to deal with now, which is the report of the committee. But thank you very much from the side of the committee to the department, and I think we will reconvene at another suitable date and time, and the department will be informed accordingly. Thank you very much. Our members, I think we'll then move to the second. Oh, I'm not sure. Okay, I'm not sure who is it. Dodovo.
I'm there, Honorable Chair.
No, no. Somebody said chair. I'm not sure who it was, but anyway, maybe it's the department. I'm not sure. But anyway, thank you very much.
I'm okay. I'm okay.
Okay, great. Thank you very much, Honorable Dodovo, because your head was up. Our members, we'll then move on to the second agenda item, which is the report on the joint proactive oversight visit by the Select Committee. It was joint oversight by the Select Committee on Security and Justice and the Select Committee on COCTA when we were in the Free State, and the report is dated the 8th of March 2023. And as members will recall, it related to the issue of the housing backlogs in terms of military veterans. The introduction and background on members, I'll not necessarily go through that, because I think we covered it in our previous, and I want to also assume that members had an opportunity to go through the report. The report covers the objectives of the proactive oversight visit. It includes the delegation that went down to do the oversight visit. We had, as members will recall, that we had a briefing by the Department of Human Settlements and the Department of Defense and Military Veterans. Okay, and we also did in local site visits. I see the document has moved to the. All right, so I think I'm not sure who's controlling it. Is it Gershwin? Maybe you need to go to page 3. Right, because on members, we did a site visit to Hillside View, or is it before? Okay. Yes, on members, so we did a site visit to Hillside View, and we also interacted with military veterans there to solicit their views. The key challenges that were identified, I won't go through that, but and all the observations by the delegations, but there were recommendations that we made, which includes that the Free State Department of Human Settlements, Department of Defense and Military Veterans should engage the construction company that has built the military veteran houses in order for it to rectify the major structural defects. Secondly, that the Free State Department of Human Settlements and the Department of Defense and Military Veterans should provide the joint delegation with the exact funds that has been spent for the past 7 years in building the 50 units, and that the Department of Human Settlements in the Free State should speedily resolve the issue of the 4 units that are not connected to the main sewer pipe, as it is a health hazard to those beneficiaries. The second site that we went to was in Ribikstad and Readers Park. Once again, I'll just go again, members, to the and also all members, if you look at the report, there was also we're also reporting on specific houses where we picked up challenges, and one of the occupants was a person living with disabilities. I'll then go to the recommendations of the joint delegation, which is on page 7, where the committee recommends that the Free State Portfolio Committee on Human Settlements should conduct a follow-up oversight visit to these military veterans' houses. The Free State Department of Human Settlements should do an inspection of all the houses and engage the construction company and the NHBRC in order to rectify all the structural defects, and that the construction company, together with the Free State Department of Human Settlements, should, as a matter of urgency, attend to the house of Mr. Mukwena as he lives with a disability, and that the Department of Copter and the municipality must ensure electrical provision to the site. I think our members, I take it that you've been through the reports. I'm going to then request whether you have any corrections and or additions that you would want to make to the report. If you can give me an indication. If not, if you're happy with the report, if there's any member who would want to propose that we adopt the report. Our members? Honorable Dodo?
Yes, I'm Chair. Can you hear me? I'm here.
I can hear you. Please continue.
Yes, I'm here. I move that we support the report as it reflects the true reflection of what we discussed and did for this purpose. I move that we adopt it.
Thank you very much, Honorable Dodo. Any seconder? Our members, any seconder for the adoption of the report?
I second, Chair, Honorable Mthethwa.
All right, Honorable Mthethwa. Okay, thank you very much, Honorable Mthethwa. Are there any objections? Okay, none. Thank you very much, Honorable members. I think the report is duly adopted. I think with that said, our members, we've come to the end of our meeting, and also let me thank you very much for your attendance and for your contributions in this meeting. I know it has been a pretty lengthy one, and given we had a bit of a break in terms of our meetings, but hopefully going forward we'd be able to stick to our schedule. Thank you very much, all members. This meeting is adjourned.
Thank you,
Thank you, Chair.
Thank you, Chair.